Hi everyone. Today is the 9th of January 2025, and I'm delighted to welcome Grant Abbott, estate planning and wills expert, author of many books to do with estate planning in relation to self-managed super funds and more. So, Grant, are you with us now?
Yeah, I'm here. Sorry about that. We've had a lot of rain up here on the Twin Waters on Sunshine Coast and was belting down, and our back patio the roof decided to spring a leak. So it was sort of like everyone was just going everywhere. So, but it's all okay now, so we're fine.
Great. Well, I hope as long as you guys are safe,
Yep.
um, that's uh, that's the main thing. The patio didn't take any animals with it, did it?
No, the dogs were very, very scared though. We've just got like a couple of little cavoodles and little baby one that's mixed with Shih Tzu, and when the lightning and the thunder comes, just freaks it out. So the eyes just go either way. So, but they're okay now. So it's all gone past us, which is fantastic.
Oh, great. All right. Well, thank you for joining us tonight.
Yeah, my
Um,
pleasure.
I did apologise that Cass's son has just had some surgery, so she was going to join us tonight, but
Yeah,
she's with him in recovery. Yes,
it's
he's a
understandable.
yeah.
Yeah.
So tonight I will be not speaking. This is Grant's first session with us. We're very excited. We've already had people emailing their questions in. Um, we love it when there's an interactive audience. So Grant is mostly happy to provide an interactive session.
Yep.
Uh, but I see you've got a whiteboard in the background,
Yeah, absolutely.
so I will hand it over to Grant.
Okay, well, thank you for that, Mary Jane. So I'll probably go for about 20-25 minutes and open up for questions. There's obviously a lot that needs to be known around that. I mean, my forte, as Mary Jane said, is in self-managed superannuation funds, and I wrote 5 books on that, and just doing a new edition of the Strategist Guide to Self-Managed Super Fund, which is all about strategies. But probably around about 7 or 8 years ago, I was married and I had a couple of stepchildren and had a couple of children of my own from a prior marriage. And my dad sort of caught me out by saying that, in the event that he passed away, um, what would happen to, mum and dad's wealth if it went to me, and I'd subsequently passed away, and said, well, at that stage, my will and a lot of my assets were joint assets with my wife, so they'd end up going to her. And then he said, well, what about our bloodline? And that sort of dumbfounded me. And, from that time onwards, I started exploring ensuring that one, family wealth is protected during life, because I've seen too many people go broke, bankrupt, lose the family home, which is a very scary instance from family law litigation, and more importantly, on death, family provision claims as well. So it's very easy. I think, Mary Jane, you sent one a question through, and I think I gave a fairly detailed answer that most people in New South Wales are shocked that you may have joint assets in the Cowp and Cowp case, which is only 4 years old now. So it's very recent. In fact, there's been a couple of very nasty cases going to the High Court recently with in this particular instance, Cowp and Cowp, that they'd been married together for like 57 years. He had a stepson. He passed away. Everything was in joint names, so shares, the cash account, and also the family home, and that went to his wife. And then his stepson was able to make a claim on the estate. And ordinarily, in most other states, they wouldn't get a leg in if you've got joint assets, although it is starting to change now, as everything gets, I'm not going to say a bit more left wing, but a lot more equitable. And as a consequence of that, she had to sell her home, downsize, which was a bit of a shock at that age. And she was okay living. The court determined that she had enough money living on her share and cash portfolio, but the stepson needed cash. So even though, when we have a look at it in New South Wales, the family provision is children, grandchildren, if they're financially dependent upon you, spouses, the big one, which probably one of the reasons I'll never come back to New South Wales is ex-spouses are also able to make family provision claims. And you might pull your hair out and say, well, hold on, the funny thing is it's a bit of an issue because I quite often see people say, but I've looked after this child all my life and they've been drug addicts or they've been hopeless in business or whatever. And I want to look after my other kids that haven't been such a burden on me. But unfortunately, it actually goes a reverse way because a family provision claim is actually there to provide for the needier members of the family. So if there's a long history of providing for that child, it actually works in reverse. It means that child is probably going to end up with quite a substantial amount vis-a-vis the other children. So it's very pernicious, but again, it's just the way that we need to work. So what I wanted to do is just go through. I'd highly encourage you. This is my latest book, which you can get at grantabbott.com. So grantabbott.com, or you can get it on Amazon. So it's Family Wealth Protection in Australia, and I think it's about 218 pages, but it's everything I know about family wealth protection. But importantly, it's just not family wealth protection, it's family wealth protection for bloodline for generations to come. And that's where I find is that many of you are probably in relationships that, been quite stable. Look, if you're in a blended family or you've got an ex-spouse, you really need to come and see me. I think it's absolutely crucial, or stepchildren. As I said, because we work very closely with Cass and Mary Jane, that first appointment's free. You just need to simply provide your broad details. I really need to know a lot about your family, where you believe there are potential risks. Definitely read the book. The book goes in through all the case studies, all the cases and areas that I've looked at over my life. But essentially, have a read there. I'm going to go and use the whiteboard. So typically, our session will go for about 45 minutes to an hour. If you come along and make an appointment, there's no cost on that. So you're getting the person who's written the only book on family wealth protection for bloodline in Australia. You're virtually getting my consulting for 45 minutes for free. So normally, if it was through my legal firm, LY Legal, I'd be charging $1,200 for that. But it's simply because of Mary Jane and Cass's relationship with us. So that's certainly something that you might want to put into account. But going back is that even if you have got a great relationship and everything's tickety-boo, I'm going to show you there's a couple of weaknesses there. And generally, it's not just a weakness at the top level. It's also going down the chain. So when you want to protect family wealth and bloodline, you want to protect it also for the next generation. So it's not much good giving money to children only to find that 2 or 3 weeks later, which I've seen in some instances, their spouse files divorce papers or separates, and then suddenly that money that you've given them ends up in a family law case. 60% of all marriages, and we have to also look at de factos. If you're living with someone for more than 2 years, they're basically taught and treated as married people. The de factos are caught under the Family Law Act. One of my daughter's 26. She just announced her engagement, which is fantastic. But she had a friend who was by her grandmother's largesse given a $2 million townhouse in Brighton, Victoria, which is fantastic. Everyone will be happy with that one. And I see this too often. We want to give our kids a leg up and all that sort of stuff. But what had happened is $2 million townhouse. 6 months later, boyfriend of 4 years later, 4 years, decided to leave. And someone sort of gave me a bit of a tickle in the ribs and said, go and see a divorce lawyer. He did, and she had to sell that home, pay $200,000 in legal fees, and he ended up with $900,000. So not a bad wicket for a 25-year-old boy who'd only been with her for 4 years. It's a lot easier. I'm going to show you a couple of strategies how to do that. But one of the most important out of that element is in family law, in litigation, bankruptcy. The first thing is the opposing counsel is always going to ask for what assets you have, and more importantly, what liabilities you have. So in that instance, it would have been much better for the grandmother, and I'll talk about it, to put the money into a trust where her granddaughter was the main beneficiary, and not only her granddaughter, but also her bloodline as well. And then simply lent that money out to her granddaughter, having a registered mortgage. Now, it would have been a nil interest loan, but a registered mortgage, so that if he did leave, there would be nothing there. And I think that's important. I always advise clients, it doesn't matter whether it's grandchildren or children, is you should always lend money, never ever gift money. If you're gifting money, you're losing an asset, a family asset. If you want to keep that in the bloodline, the better thing is always to lend the money. So even if you've got money you've given to the children in the past, make sure, if you want, come to us at Y Legal and we can draft up a loan agreement for you. Again, absolutely crucial. And I've been doing that for my daughters since they're 14 years of age. So they've probably racked up around about $80,000 to $100,000 loan amount, which is sitting from my trust. However, in the event that they get divorced, that $80,000 loan can be clawed back. Whereas if I just simply given that money out over that period of time, it would have been wasted. So let's go through. I want to have a look. There's a lot of strategies in here. I've just got it here on the board. In fact, this is I'm going to go through a couple of things here for us. So this is actually a client I worked with yesterday. So let's just go through, and then you'll be able to make your assessment yourself. So I'm going to give you a few strategies as we go along. So one of the big weaknesses, we've got our family home there that's in our name. And of course, tax drives that, because we want to make sure we get our principal place of residence capital gains tax exemption. But there's a bite in the tail. And the bite in the tail is that if you're in a relationship, and I find that this is, and I'm going to give you a strategy for it, but if it's a joint asset, so when you pass away, it goes to your spouse. The problem there is, if it goes to the spouse, it's in the spouse's name. So on land titles, your spouse has got that. Suddenly, they're exposed. If they go into another relationship, and you certainly don't want to denigrate your spouse going into another relationship or try and prevent it, if they go in another relationship, that asset is now exposed. Again, from family law perspective, you can get a binding financial agreement, which we call a prenup from a family lawyer. But I've seen so many holds driven through those, so they're not that strong. A better way, and I'm going to talk a little bit better way, called the protector. And what I'll do is I'll send a video of this strategy we come up with. It's been very popular for around about 20 or 30 years, called the protector. I'll send that to Mary Jane with a couple of other things that for you to take away, including a data capture if you'd like to come and have a meeting with me. So I'll send that to Mary Jane, and she'll send you out some links to videos and some external material for you as well. So that's one of the first ones. And quite often the children worried. I had another two daughters, and their father had passed away, left a $800,000 home in Canberra. And their mum had shacked up with someone for 2 years. They were both independently reasonably well off. But again, I said, look, if they've been living together for that, then essentially that other person is an eligible person and make a claim on the estate, which the girls really came. They'd read a couple of things of mine and seen a couple of videos, and they were a bit aghast at that. So what we had to do is we leave mum on the title, but we pull the equity out of that and put it into a trust. So we're going to talk about that. So one of the first, or two dangers we've talked about, one is with children, make sure that you always lend, you never give, nil interest loan. And remember, that money I'm going to show you later, if it comes from a trust, it's going to be their money in the long run anyway. But we've got a home, we might have investment properties, We might have jewelry, or we might have cars, we might have cash. Typically, the strategy again is you should never leave things directly to people. Now, you might leave trinkets and stuff like that, but my preference is you always put it into a trust. Now, the 99.9% of trusts that are used in Australia are completely ineffective. They're great for tax, but that's all they've been built for, because they've been driven by tax accountants. Now, all of our trusts are fantastic for tax, but what we do is we put that asset protection. So this is what I like to use, and this is what I built post Dad's little talk. In fact, you're going to see a lot of strategies my dad talked about in that family wealth protection book. But essentially, I've adopted this from the British royal family. So the first thing is we need to have a really good, strong line of succession. So we have here what we call a family protection trust. And from that, we've got the king and the queen, who are called family protection appointors. Now, when we set a trust up, a trust is a vehicle that's been around since the 12th century in the UK. It's not governed by common law. There's really not that many statutes around it. It's governed by what we call equity law. When we set up the trust, the benefit of it is we have a trustee. So all the names of the assets in that trust, whether it's a cash bank account, whether it's investment property, whether it's jewelry, whether it's cars, they're all going to be in the name of the trustee. So most of you are going to end up being the trustee there. You can have one or two trustees, provided, again, you've got that. If something happens to you, you need to have that line of succession. So what we have is succession directors. The key people, though, is a lot of the big ticket items. So the trust manages the affairs of that trust, but the big ticket items essentially are going to be left up to the family protection appointor. So they're able to remove the trustee at any point in time. So you can see there, they're really the key people there. So it might be, for example, husband and wife are the family protection appointors. The next one is, who is going to be the next person in? So if you've got adult children, it may be, I prefer to have, and I'm going to talk about what to do. I prefer, maybe if it's going to be, if they're young kids, it might be a brother, sister. So if you've got children who are under the age of 18 or 20, who really aren't up to the vicissitudes of financial management, we might have a brother or sister in there. And I'll talk about that a little bit later on. So what we have there is, we don't have any named beneficiaries. The problem is, if you've got a family trust, there's got named beneficiaries in there that are not yourself and potentially your spouse. The children who might be named in that trust can actually have you removed as trustee if you don't each year take into account their financial circumstances. Again, another case that's just coming up. So with all these things, we really need to upgrade. So the first thing is, we want to have a good line of succession. I'm going to come back to that, what happens with your adult children. Now, the important thing is, we never name a beneficiary, but we do name that line of succession. The same thing as, we've got Charles, we've got Will, and we've also got George. If Charles and William pass away, then George at age 13 takes control. Mind you, he's going to have a board of advisors. They're going to tell him what to do with the Crown estate. The Crown estate, which currently is worth 35 million Australian dollars, effectively the capital passes from king to queen, passes along the royal line, but each king and queen can never touch the capital. They can only live off the income. And that's why you see Charles is getting rid of, Harry and Meghan, and also downsizing Andrew, because he wants that money for his green or whatever he wants to do. So he's quite smart. And that's why I've been talking up a lean monarchy for probably the last 15 or 20 years, because he realizes he can't touch the capital. And that capital will just keep on going down the track. So we want to have a really good line of succession. That's the first thing. I set up an association with a number of other people 4 years ago, the Succession Asset Protection Estate Planning Advisors Association. So you can get that sapepaa.org. .au, go and have a look at it. There's an ability there. I'll send a link through to Mary Jane. There's a whole lot of videos there, what we call legacy builders. So it's just an educational portal for people looking into this. So essentially, there's no named beneficiaries, but what happens is the only people who can be distributed, so the income and the capital, again, we don't want to distribute capital because we've heard of that disaster, but the income coming out of this trust can only ever go to your bloodline, and that's crucial. And it's a bloodline of these family protection appointors. So it means not only your children, your grandchildren, but it means if your children get married or their de facto relationship, their assets are protected, because beneficiaries in a trust, as opposed to beneficiaries out here, beneficiaries in a trust do not own the assets because the assets are owned by the trust. That's the very nature of a trust. It's an asset protection mechanism. So your children are going to be protected. So what I like to do, and so we've got our family protection trust, when mum and dad pass away, then we split the trust amongst your children. Now, if you want to leave one of the children out, absolutely. If one child you believe has been looked after, well and truly throughout their life, you can't leave them out of the trust. They've got no right of recourse as against that trust. And that's really important. If you want, we deal a lot with families who've got children on NDIS through ADHD or autism or physical disability. Quite often they want a larger amount left to one child to make sure they look through it. If the child's in receipt of a disability pension, we might even take that money out and put it into a special disability trust, which has some fantastic Centrelink and also taxation advantages. But that's again, have a look through the family wealth protection book for that for a lot more deep detail. So what happens is they're protected there. Now what happens is if we've got Sally and we've got Arnold here, they're both our two children. Again, it's only for their bloodline, so it's only them. Their spouses are never going to be included. Stepchildren never going to be included. But if they have one of your bloodline grandchildren, absolutely they can be there. Now, as I said, you've got the family protection appointer up here. Here, we've got the same kids, and we don't want the same kids fighting. So what happens is they become the family protection appointer of their little sub-trust. And they also become a director of the trustee on behalf of their sub-trust. So that's for Sally and that's for Arnold. So even though they're in the same vehicle together, which is absolutely crucial for that asset protection from business, ATO, creditors, trustee and bankruptcy, family law, and also future family provisions. When it's in there, they've actually got their own little fiefdom there. So it's important to keep it all in that family line, which is crucial. So that's our family protection trust. What I like to see is obviously building that right from the start. If you've got any cash or other assets, put them over there. So if you've got your jewelry, put it over there because generally there's no capital gains tax. And then you simply license the jewelry back to yourself. So you can still use it, but the actual ownership is over there. If you've got cash, again, everything should be there. Everything. This is your vault. This is your Buckingham Palace. And then what happens from there is we can then lend that money out. So if we've got cash here and we've lent it to ourselves, for example, to do whatever we want to do that, then on our death, that money gets paid back. One of the strategies that I'll send through and give to Mary Jane is the thing that we call the protector. So we work out what your net worth is because ideally, these investment properties should be in your trust. But to transfer them over is going to be capital gains tax and stamp duty, and obviously in New South Wales as well, land tax. So we've got to be careful. So it's nice to have them on the outside, but what we want to do is take the equity out of there, gift it over here, and then lend it back to us as individuals. And there's a certain process to do that. I haven't got time to go through it, but I will send you through that video so you can have a really good look at the 6-step process. And then if we have a meeting, you can then come and ask me about that. But that would mean that on your death, essentially your estate is going to be as best as possible worth nil. And if we can get it to that, then there's not going to be an issue around family provisions because a no-win, no-fee lawyer is not going to come up against a nil estate. So what it means is that essentially the money from there on your passing will transfer over here, and it's then going to be for the benefit of your remaining spouse or your children. And it also works really well in the event you've got that joint asset as well. So it's one of my favourite strategies. Another one is we have a If for those of you lucky enough to have superannuation, or more importantly, a self-managed super fund, um, with an accumulation account and a pension account, these are great vehicles to really do. So if anyone's around about 50 and hasn't got, or around 40 or 50 and you haven't got a self-managed super fund, definitely get in one as quickly as possible. The only weakness is that is included for family law purposes. If you've got a self-managed super fund, which is quite sizable, more than $3 million account, you really need to come and see me and sort yourself out pretty quickly. But usually the strategies we do deal with here is we have if it's an accumulation, we have an SMSF will, which is cash, and that might go to the spouse or a dependent. If it goes to a spouse or dependent, then it's tax-free. And then what we do is we waterfall it. So we transfer it into this vehicle, because this is a vehicle that is protected from everything there. If you've got an existing pension sitting in your self-managed super fund, then we want to make it multi-generational. So it can actually go from grandma, grandpa, and then down to the grandkids if you want, which is super tax effective. Now, there's a whole lot of other stuff. If you've got businesses, then there's a whole lot of other strategies we need to build around those businesses, importantly. But that sort of gives you a broad idea of everything that's happening around wealth protection in, 20 minutes, or 25 minutes, so it's pretty good. Have a really good read of the book. I'll send a link through. I'll send that Protect Trust through. Have a look at SPEPA. There's a lot of articles that I've done there that are essentially available. But the last thing is the time to do all this is yesterday, because I really feel as though what I'm seeing is that, like to give you an example, a couple of things. If you get caught in a family provision claim, it's going to cost most of the estate. So over in West Australia, one of the biggest, what I'd call a small estate worth $600,000, just a gentleman's family home. He had a de facto wife, on and off again. She didn't live at his place, but on and off again for about 12 years. He gave everything to his two daughters. He just simply hadn't updated his will when his wife died. De facto made a claim on the estate. She ended up getting 40%, but the problem is, of the $600,000, by the time they got to court, there was only $80,000 left. They'd spent $520,000 in legal fees. There's been some other cases just recently in New South Wales on like $5 or $6 million estates. So if they get fighting, one was $2.5 million in legal fees. The big one that's happening now is that, particularly in farming communities, if dad or mum have made a promise to the child or one of the children that they're going to get a certain percentage of the farm, they're going to take over the farm, irrespective of what the will does or family provisions, which I talked about, people are taking them to the Supreme Court, and that promise is being upheld. But when you do that, you're looking at least a $3 to $4 million legal fee. And the ones I've seen is the poor person left, who's the defendant, ends up losing their interest in the farm altogether. So it's a very sad state of affairs. And there was only December, there was a High Court case which had upheld, again, promissory estoppel for a split of the farm. So again, the only people who get you in the long run are unfortunately the lawyers. And this is the biggest fee earning exercise going down the track. I do a lot of work in artificial intelligence in our law firm. We build, I've got around my books, I build artificial intelligence around that, so we can answer questions really easily and pop out the answers pretty quickly. But one of the first professions that are actually going to be impacted quite seriously are going to be lawyers. And that's just the way it goes. The only ones who won't are the litigators. So if they can take action against someone, then they will. It's expected that by 2050, so we're looking at what, 25 years now, that's not that far away. You remember what you were 25 years ago, $10 trillion. So that's $10 trillion is going to pass between generations. And unfortunately, a lot of that is going to be litigated. They did a study in 2015, found that 50% of all wills, and that was 2015, it'd be more now, 10 years on, are litigated. And in New South Wales, 86% are successful. So it's a no-brainer for a lawyer to go in because, and again, it's not like family law. It's not like anything else. They take 4, 5, 6 years to go through this, which is yeah, it's good for them, and they can build a new house, get a new house out of it. So they're finding more and more innovative ways. And the other one is don't believe. We've had a couple of clients where the children have tried to take guardianship over their parents' affairs, saying that mum is not of sound mind. Whenever I do that, like I always take a video and say, look, it's rubbish, but they're trying to take the money before you pass away. So just be really careful, and that's what we're there for as well. So that's probably enough of the formal part of the presentation. So happy to take any questions at all. I'm just going to have it's past 6 o'clock, past the yard arm. So like a good lawyer, I'm going to take a bit of a drink.
Thanks, Grant. No, that is certainly, I think, quite eye-opening for all of us, me especially. Um, we do have a couple of questions in the chat. If you're happy just for me to cover those, oh, well, there's two actually, cover those first. And then if anybody in online who has a chat and wants to ask it verbally, just put your hand up and we can work through those as well. So the first question was right at the beginning when you were talking about as an individual, if you have your will and so on. Wondering if step-grandchildren could make a claim in, could make a claim in this circumstance. I think you were talking about.
No. So that's a really good question. So I'll just share my screen. And what I'm going to do is I'll show you. I'll get my thing up. So this is probably the best thing. In fact, I'll send this to you as well, Mary Jane. But in New South Wales, the people can make a claim. So it's in the Succession Act. I'll just blow that up a little bit because if you're like me, and particularly if you're watching on the phone, it gets a little bit small. Includes the spouse. New South Wales is the only one, an ex-spouse, which is scary about that one. De facto partners, children, now grandchildren. So it doesn't matter whether it's child or stepchild, step-grandchild. It's only if they were dependent on the deceased. So I'd have to show that, for example, you're paying school fees or some way you're financially supporting them. So if I had a step-grandchild and I was representing them, the first thing, and look, I don't do that. I protect. I don't go into bat for people. I think it's pretty important. But first thing you'd have to do is show that they're financially dependent. And then if you can do that, then that's it. It's game on. Person in a close personal relationship. That's interesting. So anyone who's your carer can actually make a claim. Person who is dependent on the deceased includes any person who was any time wholly or partly dependent on the deceased, was a member. There was a case, 2019, where a person who used to come round to this guy who was a mechanic used to come around and help the deceased in terms of fixing up their automobile and all that sort of stuff because he'd had a bit of a dementia. And what transpired from that case is the court said, look, although he did spend a lot of time, because he wasn't living with that person, if he'd been living, absolutely would have had a claim on the estate. It's also important, really, to make sure you go and get your enduring powers of attorney up to speed now. There's expected to be around about 1 million people with dementia in the next 10 years. And I see a lot of clients down that track as well. My grandmother passed, or she had Alzheimer's for 14 years, dad, dementia for 6 years. Sir Lawrence Street, Gough Whitlam, Nifty Neville, they all had dementia. They lived a lot long, all lived in their 90s, but they all had dementia. So it doesn't matter how smart you are, it will get a grip of you. So you make sure you've got enduring power of attorney and advanced healthcare directive as well. So if you come, and generally the process is, if you come to see us, I have a look at your circumstances. We look for all the risks. If you read the book, fantastic, because you're already going to come in with some preordained knowledge. As I said, we then come with an options paper with you, so there's no cost up to that date. After that time, then what we do is we'll come in and we'll say, this is what we're going to build, a family protection trust with splitting and all that. And we're not expensive compared to, supposed estate planning lawyers. We're very reasonable. And then we'll say, look, we're building all these things. We look at super, enduring powers of attorney, anything. So, but it's all fixed price quote, which you'll get. And then if you want to go ahead, you go ahead. If you don't, you don't have to do that. It was interesting with while I'm there.
I was going to say that was a perfect segue to the next question, but if you want to
give me the next question,
lay it on. It was, what are the fees associated with setting up the trust? So I guess what you're saying is it depends on your circumstances.
It depends on what you're looking to protect, but typically, I think our family protection trust is like $2,500, which when you have a look, you go and have a chat with your accountant. He's going to set you up with a dodgy trust for the same sort of price. So that's very cheap. Our wills with testamentary trust, I think about $2,500 a piece. But I can tell you, if you went to Peter Bobbin or one of the Argyle partners, you're probably paying the minimum usually is $3,000 to $10,000 plus per testamentary trust. So we've just got a very good system that works really well.
And actually, I have just found the fees on our website, which are exactly in line with what you've just outlined. So I put that link in the chat there. But I will say,
actually, can I just say, here's the first thing is, this is the process in New South Wales. Pass away, get the death certificate, usually from the funeral parlour, funeral director. Then you'll advertise. Don't you love this? You advertise on the Supreme Court Register. And then the Supreme Court Register usually takes 2 weeks of advertising. And it's funny, that's where the no win, no fee is. The lawyers look, and they find out who the dependents are then. And then it goes to probate. And then once probate is, you've then got 12 months from the day of the death to make a family provision claim. If there's a family provision claim, if you get a lawyer, you're going to be up for probably you're going to have to tip in, or the executor's going to have to tip in at least $80,000 up front, potentially $100,000 up front, before you're going to get legal, because they don't operate on a no win, no fee. But the dependents will operate on a no win, no fee. And it's tough because, for example, with that Cowup and Cowup, he had other children who didn't make a claim. So they were left out of the mix, whereas they should have really made a claim. So you might end up having 6 or 7 lawyers into the pot, depending on how many it is. As you can see, it's like people say, well, what's the minimum I should be doing this? I've had people set up structures for $120,000 because they knew their estate was going to be challenged. In New South Wales, there's been cases where it's been challenged for $50,000. And it was argued by the executor's lawyer that, well, this is ridiculous because the legal fees are going to take up all the estate. Surely there should be a de minimis rule. And effectively, the Supreme Court said, unfortunately, no. Generally, so that's just the way it is. Some of the smaller cases may end up in the district court. Certainly not the magistrate's district court, which might be a little bit cheaper, but otherwise they all end up at the Supreme Court. And once you get a Supreme Court, you have to have a junior solicitor. So you have to have a solicitor, a junior barrister and a senior barrister, and that costs a lot of money, as anyone who's been to court well knows.
So the follow-on from the same person asking the question, Trudy, was, she said, I guess it's a little simpler if you have never been married, your ex-partner has since passed away, and you have no children.
Perfect.
Are there any things that need to be considered in this type of scenario? And the follow-on is, I have siblings, nieces, nephews, but none of my own children. Is it still required to set up a trust, as most of my money may not be going?
So yeah, because remember we had to look through all that, and as long as none of them are financially dependent living with you, you tickety boo. So the best thing to do there is really come in and you can have what we call a pretty simple will. I like to do, because it really doesn't cost that much more. I like this testamentary trust. A testamentary trust can be for your nieces and nephews, and we put a few terms and conditions around it. The nieces and nephews get so much, or it's used for education or whatever. The good thing about that protects them. It depends on the quantum there, and you can also leave it for charities through that trust as well. So that's my preference, but that's one that's built actually into the will. But again, I don't see any obvious challenges there.
Thank you.
Just don't go out and be a naughty lady and go and find someone living with you for a couple of years. Otherwise, you're going to be very in strife. So that's why I always tell people, when it gets around 18 months, you've got to start to make decisions about whether you're going to protect or you're actually going to go down the track.
Gosh. So what is the minimum? This is from Elaine. What is the minimum net worth to make setting up the family protection trust worthwhile, in your opinion?
I think it comes down to what the risk is. So, for example, with Trudy, I just told you she doesn't need one. So, but I'd like to see a family protection trust just to protect the nieces and nephews, and put some terms and conditions, because you don't want to be giving money to nieces and nephews that might end up being drug addicts, or do you know what I mean? You just don't know. What you don't know. So, putting a little trust around that, and then making one of your cousins, the family protection appointee, or put a couple of them on as trustee. It's a nice little fit. But if you're from blended families, and you've got a family home, I can tell you the first thing, that's the end of that family home. So even if the family home, and unfortunately in New South Wales, real estate values are quite significant. We talked about Calp and Calp. I would say that you're probably looking, the couple we saw in Canberra, the two daughters, the family home that the mum had was $800,000, and they were adamant that it needed to be protected. But as I said, you've got to really just sit down and have a chat with me. It's going to have no cost, and I'm a nice person too to have a chat with.
There has been Simone in the chat is asking for a photograph of what's on your whiteboard behind you. What I might
Absolutely.
suggest is, and people have been asking about the recording. The recording will be available on our website. I'll just share our website.
What I'll do is I'll get my associate Bansal to draft up a nice little diagram of all the various structures that you might have. If you're in business, you might have family protection trust, and covering all that splitting and testamentary trust. So you've got a good graphical interface for it as well.
That'll be great. Thank you. And the recording will be on our website under this. You click the YouTube, and it'll be here somewhere that I will create a new playlist for. So
good old Mary Jane, look at you. What a legend you are with all that material.
That's all right. I just need to get back to here. There we go. So that was answering a couple of questions there. We do have another. Now, Lisa, you did have your hand up, but I did actually just read out your question, I believe. Did you want to ask another question, or I've noticed your hand's gone down. So if you do have another question.
I just asked a question. You haven't asked my question.
Oh, is this what happens if parents have nominated? Yeah. Are you happy for me to read it out then?
Yeah.
So Lisa's question is, what happens if parents have nominated a sibling as their power of attorney? However, there are doubts about how the estate will be managed. Should parents' mental health, so they have doubts about how the estate will be managed should their parents' mental health decline. How can you stop mismanagement of the estate?
Yeah, so there's actually two parts to that, and that's a really good point. And I've seen, God, you can't believe the amount of fights that I see around this. So if we have a look at the first thing, an enduring power of attorney only applies when you're alive. So there's two parts. One part's the health part. So that's making decisions around health and quite often, remember that succession we talked about? We want to have that really good line of succession down the track in terms of our enduring power of attorney. Much the same as when we have our wills, we want to have that line of succession. So if the first person's not around, so if it's our spouse, they're not around, it flows to the second and flows to the next and so on and so forth. I like to see a good 4 or 5 levels of succession. If you look at the British royal family, I can go to ChatGPT and I can pull up like 50, the line of 50 of them if you want. So the enduring power of attorney is both health and then finance. So finance is the big one. And this is really where you need to put some terms and conditions around that as to, it's nice to give them the finance, but essentially they have carte blanche as to what to do with the money. Of course, there's Powers of Attorney Act that you've got to be, they've obviously got to be careful about. You can't just go and use it all to, go to the Sofitel, the new Sofitel, and Sydney, go and spend a few months there. It's got to be within reason, but they do have the keys to the bank account. Once you get enduring power of attorney, you have to take it to the Land Titles Office if you want to deal with the land, and also to the bank as well. So if they misuse the money, then it's important to make a note and make quite a verbal note to them that they believe that you're misusing the money for personal purposes. And if need be, then we can go to the Guardian Board and take it a little bit further. Once the person dies, that enduring power drops off, and then it comes up to the executor. And the executor has to complete what is required in the will. But it can end up being a bit of a disaster. We had one, unfortunately, it was a Greek gentleman who'd had like 4 or 5 properties, a couple of business or commercial properties, and family home and another investment property. He gave the commercial properties to his son, and his daughters each had, one had the family home and one had the other home. So there was no fights at all, so to speak, in terms of family provision. So he looked after each pretty seriously. But he had the accountant act as the executor. So it's quite often you want to make sure you've got someone acting as the executor, but also having someone who can administer or really be there as the backbone of the estate if there's a fight. And that's like someone like myself or Cass or Mary Jane or someone who can step in and make sure they get really good support. From that perspective, is that he got the accountant, and because he was very aggressive, the accountant, who was the executor, transferred the 2 commercial properties to him straight away, and then held off on the other properties. And the other properties held, obviously, trinkets and all that sort of stuff, which for the most part, they don't, they're nice to have, but kids these days don't really care about them. Not being, obviously jewelry, but, the Georgian furniture and all that, it's not so much. But in this instance, he came around and started complaining that, that he got the commercial properties. He really wanted the family law. He was the eldest and blah, blah, blah. He ended up pushing the sisters over, even pushed the executor out of a verbal fight and a fist fight with the executor. So whereas the executor should have said, okay, we'll all go in, pick up your stuff that you want, and I'm not going to transfer any property until it's all over. So you need someone who's quite smart. So again, you want to have that good line of executorship with support. The other thing that I will also say is, obviously some of you are younger, make sure that your parents' affairs are tied up pretty tightly, or at least suggest them. We had one client, in fact, it was one of the first people to ever buy the Family Wealth Protection book. I saw him in December, just when it first came out. He bought it, and then we caught up 3 days ago, and I said, "Oh, did you like the book?" Because I always like to have good feedback. So it was fantastic. He's from Darwin. He was quite tough because he's overseas every 3 years, so it's very tough from an estate planning perspective as to which state he belongs in, etc. Anyway, he said, "Oh yeah, well I had all my cousins and uncles and neighbours. Now we had about 35 people. We had a big barbecue, and I got the book out and I started reading the book. And he said everyone was absolutely fascinated, and no one had done anything like this. So yeah, it's quite a. Yeah, I was chuffed to the fact that I'd actually changed those sort of people. So brought almost a tear to my eye, which is great.
Well, I think this is the beginning of a floodgate opening potentially.
Yeah.
I think many eyes have been opened. So I will, Zoe, you've got your hand up if you want to ask your question, and then I'll go on to Elaine's question in the chat.
Yeah, I just had a question about protection of a family member's assets prior to going into an aged care situation.
Yep.
What's the best way to go about that?
Well, it depends on what you're protecting them from. So is it protecting from is it de facto? Is it a protecting from the children or other children? So when it comes to aged care, ordinarily, so this is what I would do. Ordinarily, when you go into aged care, you'll find that you'll dispose of the family home. That'll give you cash. I would never ever do a refundable deposit for aged care. It just doesn't make sense financially. Always go the daily fee, and I did that for both mum and dad because that frees up your cash. I would then put that cash into a family protection trust where I know that I can protect it, and it's going to be for the long term. It's going to be for the children anyway. We did that for my mum, and I ended up. Mum and dad have been in there for quite some time. Dad passed away 3 or 4 years ago, but we depleted all their resources. So it's actually hasn't been too bad because I've been able to put some of my business income into that family protection trust and pay it out to mum. So it's tax effective for me.
Yeah, I'd like to know a little bit more about that. I don't know whether I can find out.
You go in
the
before they go to
website,
the
I
aged care. Just you look. Usually depends on where it is, but like for example, Nifty and Goff, and the facility they win was pretty high dementia, and the refundable accommodation deposit for them was $3 million. Mum and dad were in Adelaide, and it was 560, and that was going back some time. Whereas when you tie up so much capital, you've also got to think about, well, what happens if they do get dementia, because they tend to last, a lot longer than normal people going into aged care homes. So they'll last, potentially 8 or even could be like my grandma, 12 years. If you've got it all tied up in a refundable accommodation deposit and not earning any income, then essentially, once it's depleted, who's actually going to pay for it? That's why I said to my brothers, like 3 or 4 years ago, they're saying, "Oh, if mum dies, how are we going to split the money?" Now it's like, well, yeah, funny you said that because now the money's run out. How do you want to help pay for it? And they've all run for the hills. But anyway, that's okay. That's what family's about.
Yeah, so it's better to have the daily fee thing rather than a.
Yeah,
Did
I
you
think
say
so, particularly if they're means tested. It depends, obviously, when it comes around to means testing, unless you've got the better it is. They do look through into the trust, so that's fine. But you expect that. So you give the money into the trust and then just pay the daily fees there. But I think mum, I think her fees, and again, she's in Adelaide, she's on about five, it started off at 4,200, now it's 5,200 a month, which is pretty good because she gets like 3 meals a day. They just feed her up all the time, and there's plenty of stuff on, so it's quite good. And she's been in there since 2020, so it's coming up to 5 years now. I think what I always tell people is before, and no one really tells anyone about this, before you put them in aged care, do your cash flow. What's it going to cost? How long it's going to get? What age pension you're going to expect out of that one? So really build that out, because again, you don't want to be left short because if you run out of money, what are you going to do with your mum or your dad? You're going to bring them back home, so you don't want to do that.
Yeah. So Grant, that's an excellent point. My mother went into aged care in 2018, and I did exactly what you said, had spreadsheets and read everything you could possibly have, but I also got a legal person to just go through and clarify what I'd discovered, and then had somebody else fantastic to go through and crunch some numbers for me. Unfortunately, that person no longer works in the industry. So if you happen to have a great referral partner who can help crunch numbers like that, I know there'd be a lot of interested people. That's just to put that on the back burner. And if I do get these inquiries from time to time because of our demographics of our clients. I haven't been able to find anybody yet. The next question from Elaine is, does this wealth protection structure apply only to assets in Australia? What if you have assets overseas?
It's a tough one because it's good and bad actually. So when you do a will, there's 17 countries, and really there's not that many, where a will done in Australia will cover overseas assets. Generally, you'll need to have an overseas will to look after those. To be brutally honest, New South Wales is probably the worst place in the world to have your assets because of these family provision claims. I had a chat with a Texan lawyer. In fact, it was really good. This is through a conference that we had. And I said, oh, look, these people can, make claims on the estates and all that. He said, Grant, if that was here in Texas, they'd be shooting each other, which is the case. So you really need to look overseas. As I said, it's not as bad overseas as it is in Australia. It's quite instructive. I don't know if any of you followed the trust about the Murdoch family trust. He'd given 4 equal parts, like here. It's an in vitro, so it's a family protection trust he built. He'd given 1 share each to each of his children, so 3 from his former wife, I think, and then 1 from was it Wendy or whatever her name was. And because he's getting a bit older, and that's why I think he's never going to die, because he wanted the Fox News network to stay conservative, but 2 of his children quite liberal leaning, so he was very concerned about it. And he went to court to try and say, well, Lachlan, who is the more conservative of the family, should have a controlling interest in what happens, not so much in the shares that they had, but a controlling interest and determination on what to do with the assets and be in charge of Fox. And of course, the other children all rebelled against that. And that case would have cost, you're looking at about $5 or $6 million easily. But again, he lost. So if Rupert Murdoch loses, it just shows you the power of a trust with all his money.
Gosh, yes. Now, this next question from Kim is a very pertinent one. If I created an SMSF will only, can this be paid with SMSF funds? Now, Grant, before you answer, well, I can answer that question potentially, but what is an SMSF will versus another will?
Okay, so that's a good question. So what happens is each state has its own like succession or wills act. So in New South Wales, you've got the Succession Act, and essentially from that it talks about how to distribute assets. Superannuation is governed by federal law. So if you don't pass superannuation, and I'll come back to this for New South Wales, unfortunately, if you don't pass superannuation to your estate, then it's not caught up in probate and all that sort of stuff. So what we want to do is, with superannuation in the past, industry and retail funds use a thing called a binding death benefit nomination, which is it's a bit of an abomination for a self-managed super fund. So it's a set of directions saying, look, this is what I want to happen. On my death, I want to give this amount. So if it's going to go to a dependent is the spouse, child, adopted child, financially dependent person on you, such as a grandchild, brother, sister, anyone who's financially dependent, they can all be looked after directly from the superannuation fund and be kept out of the estate. And we do that through a process called using a SMSF will, and that can go directly to them, or it can go into a trust, which would be that sort of style of trust. Again, you don't want to give people money, you want to protect it. If it's going to go to someone who's a non-dependent, so for example, a charity, well, you can pay it directly out with charities, but it's going, for example, to a brother or a sister or niece or nephew who aren't financially dependent, then we have to go to the estate. Now, in every other state in Australia, if we pay money directly out of super, if there's a self-managed super fund, an SMSF will, it's not included in family provisions, but there have been a couple of cases, as you can imagine, in New South Wales, where superannuation's been caught up. It's in this concept called notional estate. That's how they use that cow-up, so that there might be an award for family provision, so they go through the whole process, but the estate may not have enough money for that award. So what they do is they go around looking for other things that might be this notional estate, and that's how they picked up that joint family home in Cowup. And there's been a couple of cases, Kelly's case, and I forget the other one, Barclay or something, where they've gone into superannuation. I believe superannuation it's unconstitutional on the Tasmanian Dams case, but it's only just nascent. At some point in time it'll be argued. In fact, I'd like to argue that case, but we'll wait and see. But an SMSF will only deals with your superannuation. There's been rulings from the Commissioner, been High Court cases that say whatever, and this is how you can tell whether you've got a good lawyer or not. If a lawyer tries to deal with superannuation through a will, it's all completely hopeless.
And thank you for that. And if it is an SMSF will only, dealing only with the SMSF, it can be paid out of your super funds. Okay?
Absolutely, to a dependent.
Yeah. So the next question is just for clarification from Matt. Is the Family Protection Trust a type of testamentary trust?
No, that's a really good point, Matt. The Family Protection Trust, what we call an inter vivos, is something we set up now. Particularly if we're looking at, remember I said the best thing to do is always look at this as our Buckingham Palace. So we can transfer cash in there. We might have that protected, which I'll send you through. A testamentary trust comes from your will. The problem about that is if you've got a family provision claim, then the testamentary trust does not happen until that family provision claim is actually litigated. So you might have these testamentary trusts for people, but then you find out that there's nothing left in the estate to do a testamentary trust for, if that makes sense.
And also Yash has put some information in the chat there, which fleshes that out a bit more. Elaine has a question. What is the cost and effort in maintaining a family protection trust? For example, is there a tax return or accounting or other paperwork or compliance?
Yeah, there's it's like any vehicle. Remember, you're actually setting up a separate entity, and you want that because you don't want it part of you. So you'll end up getting an ABN, TFN, a bank account. So you get the family protection trustee, take it down to the bank. The bank will scan it and then we'll set up with a bank account. Now, for the most part, it depends on what assets you have in there. Ideally, you're going to build it up over time. But if you only just got like a cash account, you've got a few of these protected, which are just loan accounts, there's not a huge amount of work to be done. So it's going to depend on what Cass and the team are actually going to charge you for that trust. As I said, we set up the structures to protect the wealth. We don't go into the ongoing accounting administration of that.
So, but it would be an entity on its own, and therefore dealing with finance with its ABN and tax file number, so it would need to do an annual tax return.
Correct.
And I will need to discuss the fees with the accounting section on that. So stay tuned. Sorry, I can't give you the head off, but the compliance aspect would be it's all be part of all that.
It's funny, actually. I should go through, because a lot of people dwell on the costs, but they don't look at like a classic case. I look at it as an insurance policy. You have a look at what's happening over in LA at the moment. So a number of those people at Pacific Palisades, which I know really well, in Malibu, their insurance companies actually cancelled their policies about 4 or 5 months ago. Now, there's nothing worse than being caught without insurance. You lose everything. And I have seen instances here with the financial planner, believe it or not, and we were going through the process of protecting his business and his assets, as we saw there. And then he was sued by a client and lost his license. And of course, that put everything at risk. He lost his home, everything. And he came to me 6 months, came to me about a week or two after all this happened, and said, can I, once all the litigation started off and ASIC wrote off his license, can I put this in now? I said, well, I would talk to you about 6 months ago. Now, unfortunately, it's too late.
Yes. Yes, the time to do it was yesterday, as you said at the beginning.
Yeah.
So Elaine's continues is, does this family wealth protection structure work for income and non-income producing assets, or should it produce a reasonable amount of income to be viable?
No. You can have it just for capital gain assets. In fact, it's probably the best thing to do, because then you don't have to worry about income. I mean, the best thing for all of this, because you've got some great questions, read the book. Like we're talking about family protection trust, but there's about another 10 trusts that I go into in there, and a whole lot of estate planning strategies, family law strategies there to protect for your children as you go down the track. Insurance strategies, many of you got children, and I remember for my auntie and uncle, their daughter passed away at age 34, 35 with leukemia, had 3 kids. The husband who shacked up with the neighbourhood wife didn't get to see, my grandparents didn't get to see their kids for 10 years. And by that stage, they were living in a garage. Whereas if they'd had insurance over their daughter, which would have been next to nothing, $300 to $400 per annum, they could have made sure they looked after financially their grandchildren, and made sure they came and visited them.
All right. Well, that's sobering thought. So thank you very much, Grant. We don't seem to have any questions remaining. We have reached 8. It's 8 o'clock here in the ACT, 7:15 or 7:11 in Queensland, where Grant is. Grant, this has been really informative, really interesting, and I know that the more that people see this video and we talk about it, that people will be interested in asking more questions. If you're available in a month or 2 months, we might do this again. In the meantime, this video will be available on our website. If you are interested in following up, send me an email. There's an email in the chat there, mary-jane@freedomffs.com.au. What happens then is I'll send you a short piece of paper to fill out, so we've got your details, and I'll pass it through to Grant and his team, and then they will organise a time to have that initial free consult with you. And
if you read the book beforehand, you're going to get, by the time you get, we'll be really having a really good, strong chat. So because there's nothing more motivational once you look at strategies, because you'll go through and you go, understand how that applies there. I understand how that applies there. And then you can actually ask me a whole lot of questions there.
Yeah, no, I'm looking forward to getting my copy of the book.
Vanessa will send you a copy tomorrow.
Well, I did order it just before Christmas, thinking Christmas reading.
They're all posted out today.
No,
getting it on Monday. Yeah.
No worries at all. And just so you know, the book, if you buy it from our website, and I will just share where it is so that you can see it very easily. If you go to news and events, and you go to estate planning and wills, protect your legacy, there is a link there which gives you a discount. So you can see we get a discount. The link is also in the chat in this recording. So with that, thank you very much, Grant. And
My
Grant,
pleasure. So time for me to go and cook steak for my kids. So watch out. I've got my adult children here, or they've come up from Melbourne, so they're enjoying the hot weather. But we're about to have a nice big steak and a red wine, so it'll be lovely.
Sounds delicious. All right, thank you very much for everyone joining tonight. We'll wind it up there and we'll stay in touch. Bye-bye.
Okay, bye.
Thank you.